Well, good morning. We're here today on Michael Hill versus FedEx Sedgwick, file number WC 246585. Today's date is February 3rd, 2025. This is live stream and also being recorded. I have here representing the appellant, employer insurer Christine Tuft, correct? I also have here representing the employee Stephanie Balmer. As you both know, as veterans of the appellate level practice, there are 15 minutes each to make an oral argument. You may reserve such time as you believe is necessary. I will go forward with an allowance of 3 minutes uninterrupted time, at which point afterwards my colleagues or myself will interrupt and start to ask questions if we believe we have questions here before you today. Are there any questions by council before we begin? Thank you. Ms. Tuff? Thank you.
Good morning. May it please the court, council, Judge Quinn, congratulations on your reappointment.
Thank you.
I'm Christine Tuft. I represent the employer and insurer in this matter. This case presents, I think, kind of an interesting procedural dilemma, and we've raised the legal procedural issue of expansion of the issues on appeal, as well as the factual issues of substantial evidence to support the findings in this matter. So with respect to the procedural issues, it's our position that essentially the judge expanded the issues and or did not apply the correct standard to the issues presented. So this case came before the compensation judge pursuant to our petition to discontinue. And specifically the amended petition to discontinue laid out 4 bases for discontinuance in this matter. The first basis was that the employee did not suffer a work injury that developed into CRPS. Secondly, if there was any injury, it fully resolved. Thirdly, the vascular issues are not work-related. And fourth, that there's no need for restrictions related to the work injury. When we were up there on the, before the court on the petition to discontinue with these issues, she read the issues into the hearing transcript. Those are the only issues listed in this matter. What happens when you read the findings in order and you look at this is that there seems to be in part a shifting of the burden in the matter, but also in part either a decision on or expansion of the issues without making determinations on the issues. And specifically, if you look at her ultimate findings or order in this matter, she indicated that the evidence failed to show that the effects of the work injury fully resolved. But one of the issues that we had listed on our petition to discontinue was whether there was actually a work injury. She did not make ultimate findings on the issue of the work injury. And that's where I come around to this being a bit of a convoluted situation factually in this matter. So in addition, she found that the employee established that there were ongoing effects from the work injury. Again, essentially finding that there was a work injury without finding that there was a work injury, without making findings related to there being a work injury. So, the judge made, in our estimation, ultimate jurisdictional findings that there were a work injury. There was a work injury without making a determination regarding there being a work-related injury or the nature and extent of the work-related injury, although she seems to have found that it was CRPS on it.
Ms. Tuft, I'm going to interrupt you.
Go
You
ahead.
said the judge found that the employee established ongoing restrictions. Did she find that?
Let me just find the exact.
I mean, I know there's mention in the memorandum that she found Dr. Rip's opinion to be persuasive, um, and Dr. Jorgensen, but I don't see a specific finding that, and certainly not one that was appealed. The only ultimate findings are the employee's credible and your client did not satisfy its burden.
Um, Thank you. In the first paragraph of the memorandum, um, she said that the employee must prove by preponderance of evidence that work injury is a substantial contributing factor in the employee's ongoing disability and need for restrictions. And then she says, based on the following, she concludes that he met that burden.
Okay.
So that's where I'm
So it's
getting
more in the
that.
memorandum than in the findings itself.
Correct. Yeah,
Okay.
because in the ultimate findings, you really don't find a lot of ultimate findings. You find a lot of recitation of the evidence presented, but she
Sure.
only finds credibility, and then she finds that the employer and insurer did not establish what we wanted to establish, but she doesn't make any other ultimate findings.
All right, and so if we were just to focus on the findings and ignore the memorandum for a
Mhm.
moment, the finding that she did not find your evidence persuasive enough to discontinue, that just is then just substantial evidence review, correct?
Well, I don't think it's quite just substantial evidence, because what she finds is that the evidence fails to show that the effects of the work injury fully resolved. And one of our arguments is that there was no work injury in this matter. We got there a little bit differently because they initially had accepted an injury and paid benefits. So when they got the original IME report saying that there wasn't a work injury, procedurally, we had to go through the NOID process.
Right, I understand that.
For
It was more
that.
than 60
So-
days and you
Correct.
have to do those things.
All
right.
of that. So, but she seemingly makes that finding, which is a huge part of what prompted the appeal in this matter, because there's a claim petition pending, to which we filed an answer saying that there's not a work-related injury, that we're retroactively denying primary liability. So, when you look at finding 34 and then read her memorandum, there's a presumption made that there's a work injury there without actually finding the work injury or finding the nature and extent of the work injury. And
So therefore, are you requesting
Well-
back to the trial level so that they can address that issue?
I do think that that's, procedurally what would need to happen here, Your Honor, is that, if that issue, which we think is necessary to deciding other issues in this matter, isn't decided, which I don't think it is, the fact finding has to go back to the judge to make that determination.
So I have a question. You go into a 239 conference, and that's in January
Mhm.
2024. And when I look at 239 conferences, it's pretty much a speed bump on the road to trial. Thumbs up, thumbs down, you're in or out on the basis of the evidence. There's no official record. And your client's lost.
Mhm.
So the continuation of the benefits moves forward, and you move to file a petition to discontinue.
Mhm.
During that time, there were extensions that you sought, counsel didn't disagree with because their client's getting paid, that you continued to address as you built up the independent medical examinations of different doctors to support a defense.
Mhm.
So you don't even get to a hearing at that point until July, 6 months later. At that time, the parties haven't consolidated the claim, petition, and answer, and you're there just on the petition to discontinue. Do you have a copy of the trial transcript?
Yes.
If you go and you set forward to the compensation judge what the issue is, and I could be wrong on the page. You presented the issue and you agree that the employee no longer has work restrictions related to the work injury. To me, that's different than there is no work injury. That's what the compensation judge decided on that date based upon what you stated, or not you, but counsel stated was at issue. So there was an admission of a work injury. And I understand with the buildup of the independent medical evaluations that as you moved forward, you're kind of looking for the redress of something of a temporary injury resolved, no release to return to work, no residual disability. We're at MMI. I get to what I would say Couts versus Sutherland. We're done. But that's not what happened here.
Well,
So I understand you're coming before us today saying we never did the admission and we have a primary denial, but that's not what you told the compensation judge on the date of hearing.
well, I'm not sure what page you're referring to, Your Honor.
Well, if
but
you go back to, and again,
I can help, page 6.
Page 6, we laid out I wasn't the trying attorney on it,
Mhm.
but the attorneys laid out
Mhm.
the grounds for discontinuance of benefits. But with respect to the work restrictions piece of it, that presumes that a finding of an injury is found. The number one issue is that the effects of any work injury have resolved. Number two, the symptoms, and number three, no longer requires any restrictions for the
and
work
that
injury.
is different than to come forward and say, Judge, I want you to make a determination. There is no injury.
But
There
we
is no
did lay
injury. It's a
out-
vascular peripheral. We have the evidence. There is no injury. We revoke our admission of liability. We were wrong.
Right.
That would be a different issue than the work injury has resolved.
Well, but that is what we laid out in our petition to discontinue. We laid out 4 specific grounds for it. And procedurally, I know everything isn't in front of this court on how we got to the continuances and, some of the other procedural factors in this matter that you went through that led to it not getting to a hearing until July. And I understand what you're saying, Judge, but the relevant pleadings in this matter and 176.238 subdivision 6 is very clear that the issues before the court on a petition to discontinue are the issues outlined in the petition to discontinue unless the parties agree to expand.
And it seems to me there was no disagreement for the expansion of that issue when you set forth in the trial transcript what the issue was. And that's what I'm getting at. So yeah, you had a path of more than one way. No injury, injury resolved. The combination of the two, not understanding what in fact the continued day symptoms, whether or not attributable solely to this or substantial contributing factor, were all on the table based on the independent medical evaluations from very good doctors that came forward. And now you're up here saying the judge expanded it inappropriately and we should remand it or reverse.
Well, first of all, I think if you read the transcript as a whole, it was clear that we were arguing that there wasn't a work injury.
That was
in
one
this.
of the arguments.
Yep, definitely was one of the arguments, maybe not exactly defined, in the issues, but definitely was one of the arguments that there was no work injury. And that's where I'm saying it's kind of is there an expansion of the issues or, did she fail to make findings on the issues that she should have made based on what we put before her with the petition to discontinue? And I'm not sure exactly procedurally what the right, argument, way to state that argument is ultimately on that. But, ultimately, if you look at the findings in order here, there's not any ultimate finding other than the employee is a credible witness. Then we fail to show by a preponderance of evidence that the work injury has fully resolved. But there isn't a finding on
We
what
presume then that she found primary liability by the way she phrased that?
Well, I mean, I suppose you could presume it. I mean, that's ultimately what, we're stuck with if this is upheld, is that there's a finding that there's a work injury without any finding that there's a work injury. There's a finding regarding it being CRPS, I guess, without any application of the rules for a determination that there's CRPS. And those are jurisdictional. I mean, those impact the rest of the procedure in this matter. And that's why we think it's important that if you're going to have those determinations as part of your determinations, that either that's, maybe it should have all been consolidated, Your Honor. I don't know, procedurally where we would have been on it, but my clients were paying benefits, and still are. But, to make those in a two-sentence finding, to have that two sentences control everything else that's going to happen in this case without making findings on why this is a work injury, what support there is for this being a work injury. And I'm going to run out of time here, and I would point out to you the facts that I don't think support those determinations.
Well, so I'm just, I'm thinking this through too, because you presented your argument, quite frankly, better today than I thought it was in the brief. So I understand your argument much better now. If we presume that the compensation judge found there was a work injury and that's all she really did, plus found that your client didn't meet its burden, the nature and extent of the work injury is still out there, unresolved, whether it's full. I mean, again, I know she made some comments in her memorandum about, I didn't believe this doctor and I did believe that doctor, but those aren't necessarily findings. So can it just be your client hasn't met its burden to discontinue? All other issues other than primary liability are on the table for that future claim petition that is apparently out there.
And I see I'm out of time.
Yeah, well, please,
Go ahead and
please,
answer.
yeah.
If the findings and order somehow could be read to only say that she found that there's an ongoing work injury, but that the nature and extent piece of it hasn't been determined, although I disagree, I can see what you're saying, but we read the memorandum. I mean, I know the memorandum is not a finding,
Right.
Per se, but the memorandum implies, and this is the third bullet point in the memorandum, the opinions of Dr. Ripp and Dr. Jorgensen, that this condition and CRPS and or chronic pain syndrome symptoms can exist concurrently are most persuasive, certainly creates the implication that she made a determination that CRPS and or chronic pain are the injury, or the extent
Sure.
of the injury.
Yeah, and I
in this
get that. I get that's
So-
the complaint. And I mean, if the findings and order existed without the memorandum at all,
Then we would still have the argument of what does finding 36, I think,
34,
mean.
yeah, what does 34 mean?
In
And I
there,
get that.
34, sorry, mean in there. But yes, and then we've got the claim petition coming along and presumably would address nature and extent arguments. But it's hard for all of us to ignore the memorandum,
Agreed.
even if maybe case law says that that's all it is kind of dicta type information, but we're going to be back in front of the same judge.
Right.
So it's hard for us to ignore that it looks like she made that decision.
I follow you.
Isn't it still open that the injury will resolve, that it was temporary, that there's no residual disability, and the continuation of the symptoms are a neuropathy completely unrelated? I mean, isn't that all still open?
Maybe it's hard to tell. I mean, again, because
Is it?
there's not any ultimate findings. Well, she just says the preponderance of evidence fails to show that the work injury is fully resolved without restrictions.
Right, but the compensation judge's jurisdiction is only through the date of the hearing.
Right, but we don't know whether by 34 she means that it's a permanent condition. We don't know if she means that there are permanent restrictions, because it's such a vague determination without other findings to go with it.
So if it's not in there, it's still,
We have to litigate it more. So, I mean, and then we're arguing with the judge about what she meant in her original findings and order, which just, don't have that clarity that I think helps the parties or, this court to decide what she meant to decide.
Thank you, Ms. Tuft. I have some questions. I know you're out of time here, but first of all, thank you for the argument on that. And you're right, it's a fundamental issue, whether or not there's a work injury,
Right.
and it should have been addressed, in my opinion. So, but I want to get to another point, and that is what was raised in your brief about the burden of proof. Is it still your argument that all you needed to show were reasonable grounds to discontinue?
Right, that is my reading of the statute, Your Honor. I know that that's the 239 portion of the statute, but 238 flows from, determinations in part made under 239, and 239 says that in order to discontinue benefits, an employer and insurer have to establish reasonable grounds to discontinue benefits. There's not a lot of case law defining what reasonable grounds is, and I've argued 239 conferences in front of one of you before, and we all know that everybody looks at it, differently. But the same mechanism is applied to get up on the petition to discontinue. It flows from that same, statutory, piece. The issues are limited to what's raised on the petition to discontinue, things like that. So yes, it's our position that we had to establish reasonable grounds to discontinue benefits. We think that the evidence clearly establishes reasonable grounds to discontinue benefits.
Is there anywhere in the statute that says a petition to discontinue filed? It has the burden, the party filing the petition to discontinue only has to establish reasonable grounds, because my understanding reasonable grounds is only associated with an administrative conference, a 239 conference.
Well, and that's what I'm saying, Judge, is that I understand that the 239 provisions that are the administrative conference provisions are the ones that state reasonable grounds to discontinue benefits. But if you disagree with the 239 decision, your next move is either an objection to discontinuance or a petition to discontinue under 238, which it doesn't, just says it's a de novo hearing. It doesn't say that it's not still the question of reasonable grounds to discontinue. So it's our position that the statute can be read as saying that what we have to establish at the de novo hearing under 238 is reasonable grounds to discontinue.
Thank you.
Right. Thank you all.
Judge Quinn, do you have any further
No,
business?
I'm good. Thank you.
Thank you.
Thank you.
May it please the court. My name is Stephanie Balmer. I represent the employee appellant Michael Hill. We are asking this court to affirm the compensation judge's finding and order. I'll address each of appellant, employer, insurer's points separately. First of all, with respect to what seems to be the main issue is this expansion of the issues. Our position is that, first of all, primary liability was not addressed by Judge Marshall. And second, if it was by agreement and or waiver by appellant. As I laid out in my brief, we started with the NOID, wherein primary liability was alleged, along with a number of very precise issues. And then we move on to the petition on discontinuance, same issue. As the court has already mentioned, there was an oral listing by the compensation judge about what the issues to be determined were, to which appellant, employer, insurer agreed. There certainly was no objection. And then finally, we have the findings in order. And I agree with counsel, actually, that the findings were quite limited. There wasn't a lot there. And I respectfully maintain that that was entirely appropriate here. The 239 process is meant to be expedited. It's the design of the legislature for a very precise reason. It's meant to be this somewhat of a shortcut. As the court indicated, it's initially a thumbs up or thumbs down, and then we move on to a full evidentiary hearing, which is what we had here with the compensation judge. And I believe that she issued exactly the decision that was put before her, not only under the Minnesota Workers' Compensation Act, but also by the petitioning party, appellant. I think it's supposed to be vague. I think that's the purpose here, because she wasn't meant to address bigger issues in an expedited hearing process. And so here we have a very narrow set of issues, and our position is that the judge decided only those very narrow issues. With respect to appellant's position on reasonable grounds, our position is that 239 addresses discontinuances only and not full evidentiary hearings, and we maintain our position that the preponderance of the evidence standard applied there as it does in all evidentiary hearings. The court had indicated maybe the compensation judge should have decided primary liability. With respect to that, our position is, again, even if the judge should have or did address primary liability, appellant was on board for that. Again, with the originating documents, out loud at hearing, with all of the doctor's reports addressing primary liability. And so even if she did address primary liability, appellant asked for it and then agreed to it. Again, going back to the expedited conference issue, 239 conferences address a very narrow single point in time. At the point when appellant wants to discontinue benefits, does the injured worker continue to suffer from limitations as a result of the work injury? There's a reason that it's a very narrow analysis, because if we were going to be asking the court to decide more issues, then it would be probably a violation of due process to force the parties to an expedited hearing on bigger, broader issues that required more discovery and more extensive hearings. The third,
Counsel, why
Yes.
wasn't the claim petition and the answer added into for purposes of the hearing that was held in July?
I didn't believe I had the right to do that. But I
Motion?
will admit that as I was responding to appellant's appeal, my position has typically been when there's an expedited hearing that it's on the employer insurer to move to consolidate, which I have a habit of doing because I would prefer a single decision on all of the factual issues. But because it was a matter of my client continuing to receive benefits or not, that it was within the employer insurers. But I
How
don't,
many motions for an extension of time from those 6 months were made?
don't recall, Your Honor.
Did you make one, or were they all made by the employer insurer?
I know that I made one because what happened was the employer insurer submitted the 2 additional independent medical examinations, and I did not have enough time to respond to them.
Ms. Palmer, would you
Yes.
agree that the issue for primary liability is a fundamental issue that should have been addressed by the compensation judge?
No.
Wait, you don't think it is a fundamental issue that should have been addressed? Is
I
that what
believe
you're
it's a
saying?
fundamental issue, but I don't believe it was before the court in the expedited hearing. Because I believe that the judge was meant to decide whether the injured worker remained eligible at that point in time. Primary liability, if the employer insurer had moved to recoup the benefits paid, for example, that wouldn't have been up for the expedited hearing.
So are we supposed to infer from the totality of the evidence that primary denial was addressed? And isn't that a slippery slope?
I don't think we are meant to infer it, Your Honor. I think there was a reason the decision was short and sweet. I think that goes along with the expedited nature of the process.
What is the average time for an expedited process? 6 months seems like a long time.
I agree, Your Honor. I couldn't speculate because my client was continuing to receive temporary total benefits. I was not in a rush. We did have this claim petition, and that was another point I wish to make, because one of the positions of the appellant was that primary liability should not have been decided in this proceeding, or if it had, it should have been done differently. But it should have been addressed, or it would be addressed down the road at the claim petition hearing. And my point on that is, what if we hadn't filed the claim petition? The expedited hearing process is one of many procedural devices about which this court is well aware. Workers' comp is very procedural, and in this state you can have multiple proceedings, a rehab conference, a medical request conference, a claim petition, a discontinuance. You can have all of these proceedings pending at different points. I'm not in charge of the process, but there are arguments to be made for corralling those processes. There are reasons why lawyers and judges do not at various points. But my point is that it happens frequently. It's part of our system.
So what's the remedy? Is this a remand? Primary denial is the condition precedent to a finding of the continuation of payment here, or not?
Is the court asking what I'm
A
proposing?
remand?
I'm proposing an affirmation, an affirmance. And then I think that the other hearing should take place. And I understand that the judge postponed the September hearing. I respectfully think that it didn't need to be postponed because I think that the 239, the expedited hearing on which we're here today really only addressed a single point in time. And I agree with counsel that there are several other bigger issues to be determined, which I also expected would be addressed at that claim petition hearing.
So if we affirm, as you request, our decision could say something along the lines of, we're affirming this very specific, discontinuance issue, but the remaining issues, including primary liability, are still on the table.
Yes.
Now, what Ms. Tuff said is essentially, but the genie's already out of the bottle by the judge's memorandum. We kind of know what she thinks about the medical opinions that are out there. Does that create a problem?
No, that's something that happens in this process frequently. You have an earlier decision, which becomes the law of the case, and it applies down the road. I'm litigating cases from the 1980s where judges have made decisions and we're still arguing about what those doctors' opinions mean. Especially when someone continues to treat, the facts change. And the final point on appeal was the substantial evidence issue, and I addressed this in my brief. Our position is certainly that this is an area where the compensation judge's decision should be left to stand based on the facts. She did make findings of credibility with respect to the employee and analyzed why she assigned different amounts of weight to the various medical opinions. I think it's well established Minnesota law that part of the decision should also be left to stand. So unless the court has any additional questions, take a seat.
Thank you very much.
Thank you.
Well, I believe that concludes this hearing today. The record's now closed. We'll make a decision within 90 days. Thank you both very much for your compelling arguments. And you guys have a good rest of the week.
And with that, we're done. Thank you very much.
Oh, you too. My little watch goes off when I have an abnormal heart rate. It kept going.
Recording stopped.
And it makes noises. I can't figure out how to make it stop making